Okay, good morning. Let's go ahead and get started. Again, this is Marcy Brabender. I'm covering for Michelle Jones this morning. And we have Kathy from Insource doing special education 101 for us. So Kathy, you want to go ahead and take it away?
I will. Thank you so much, Marcy. I'm sorry I called you Joy earlier. But well, we're all here together, so just don't call me late for dinner. But other than that, I guess we're okay, right?
Yes.
Okay. Well, thank you so much. I really appreciate the opportunity to address folks that are kind of our frontline people in working with families that have children with disabilities. And I've got a lot of great information that I want to share with you today that I hope that you'll be able to take back to your parents. I did provide some resources that hopefully you've gotten, and I'll try to remember to talk about those throughout the presentation, or at least at the very end. Some pieces that I think that you'll really want to print off and share with parents and kind of keep for yourself, to share, or just to kind of remind you when you're working with these families. So my name is Kathy Boswell. I'm a regional program specialist with Insource, Indiana's Resource Center for Families with Special Needs. I've been with Insource for almost 13 years now, and I actually volunteered for Insource for 10 years prior to that, and I got involved with Insource because I was a foster parent, and I started having some children come into my home that had disabilities, and I didn't really know a lot about the process. And Marcy, can you hear me?
Yes, ma'am.
Okay, because I'm getting a message. My network connection has been reestablished. Made me a little nervous. I thought somehow I'd gotten kicked off, but okay. Sorry for the break.
You're fine.
Okay. And I needed more information, and so I did the volunteer training with Insource, and it gave me a much better understanding of the special education process, and enabled me to actually advocate for some of these kids. And so that's what we're all about. Insource is a parent training and information center, and that's what we do. We train parents, we give them information, and we hopefully we're creating some effective advocacy on the part of parents for their children. Before I get too far into the presentation, I have to do the legal disclaimer. Insource is not a legal services agency. We're not attorneys. We do not give legal advice. So anything that I'm presenting here today is informational in nature. And of course, parents always have the right to consult with an attorney if they feel that they need some legal guidance, or they have legal questions that they would like to have answered. That is certainly their right. Just briefly about Insource. Again, we're that parent training and information center that I mentioned earlier. We are not advocates per se. We advocate for the process. And so our role is to educate parents, inform them of their rights, help them to navigate the special education process, and hopefully along the way build better and stronger working relationships between parents and schools. They can hopefully work together and get better, better resources or better services for their children. We were founded back in 1995, and we are part of a national network for parents. And our services are free, no charge to our parents. We're funded through grants from the Indiana Department of Education and through the United States Office of Special Education. There are regional offices throughout Indiana. Most of us cover multiple counties. I am up in Northwest Indiana. I'm a region rat. I serve the south half of Lake County, plus Newton, Jasper, and Pulaski County. So whatever county you might be in or your families might be in, there are staff out there that are willing and able to assist families and you as needed. And please feel free to contact any of us if you have specific questions or concerns, or refer or have your parent contact us they would like that type of assistance. Spend a lot of time on the phone, answering questions and trying to provide a little bit of guidance. We do classes such as what we're doing right now, in-person webinars. We do sometimes attend school meetings as needed. We have a great website, insource.org, and if you haven't been there before, I would encourage you to go and look. We've got lots and lots of resources and publications that are available there. We've recorded some online training classes. Some of these trainings are not very long, or the online videos, if you will. They're not very long, so you can kind of go and look at each snippet as you have time. We do have some archived webinars as well on a number of topics that I'm pretty sure staff and families might be interested in. And you can also find our calendar of training events, so people can look and see if there are any in-person trainings that are happening in their area. So basically, this is an overview of what we're going to talk about today. I'm going to try to go through this quickly because I do want to entertain questions as we have time, and just kind of, hit the highlights on some of those resources that I shared. So we're going to talk about the process itself, the special education process. We're going to spend time talking about the parents' role in this process, because they do have a role in this process. And then a little bit about resolving disagreements between parents and schools. So the Individuals with Disabilities Education Act defines special education as specially designed instruction that meets the unique needs of a child who has special needs, so that the child can benefit from their education. So you'll notice specially designed instruction. You need to keep that in the forefront. If our kids did not need specially designed instruction, then we wouldn't call it special education, we'd call it typical education. So the fact that these kids have been determined to have a disability and that there has been established a need for something a little different or special based on their unique needs, that's why we call it special education. And so specially designed instruction is what we put in place to meet those unique needs. And these services are provided by the public school system at no cost to parents. And it can include a variety of services, not just teaching, but not the actual teaching, but special occupational therapy or speech services or whatever. And again, it's at no cost to parents. Parents have a lot of rights in this process, and we call these procedural safeguards. This is just a very brief summary from Navigating the Course, which is a fabulous document, or book, by the way. And so these safeguards affirm the rights of a student's parents to be fully informed about the special ed process and about their student. Parents have the right to participate in this process, to receive prior notice before the school takes an action, and to provide consent for things at certain points along this process. They have the right to have their information maintained confidentially. Parents have the right to examine all relevant school records, really, really important. And they also have the right to resolve disagreements between parents and schools. And again, this is just kind of that in a nutshell. But what's really important is that pretty much at every meeting that you go to, school is probably going to be offering parents a copy of Procedural Safeguards. It's a big book, and a lot of parents won't take them anymore because there's so much there. Please encourage your parents to take them each and every time, and better yet, to actually read them. You would be amazed what's in this Procedural Safeguards document. Basically, it outlines everything from Article 7. And it also has your contact information to reach Insource if a parent has questions or concerns. So please encourage your parents to take these procedural safeguards. It's very, very important. Okay, so we've kind of conceptualized the special education process as a series of, circles or balloons, and each circle represents a specific step in this process. And so clearly the first step is going to be referral, because there's got to be a gateway, and the gateway is the referral process. And so who can make that referral for an evaluation? Parents can request that evaluation. Parents may do so verbally, but I strongly encourage them to do everything in writing, date it and sign it. Email is wonderful because you can email the school and keep a copy for yourself so that you know the date that you made that request. And that's important because when the public agency or the school receives that request for an evaluation, the school has 10, that starts a timeline, 10 instructional or school days to review the child's records and then to decide maybe we should evaluate this child, or maybe we don't feel that at this time that would be appropriate. But at any rate, they have 10 school days to do that review, and also within that 10 days to give the parent a written notice of the action that they're proposing. If they've agreed to evaluate, they have to tell the parent in writing that they are going to evaluate. If the school is refusing to evaluate, they must also tell the parent that, but they must also tell them the reason why they are refusing. And the parent does have the right to disagree with that, by the way. So for our purposes today, we're going to pretend like the school has agreed to evaluate. And so at that point, the school then needs written consent to proceed with the evaluation. Requesting an evaluation and consenting to an evaluation are two separate steps. So keep that in mind. If you get the notice that the school will evaluate, parents need to be asking for that consent form quickly, because that then starts another timeline. When the parent signs consent, the school then has 50 instructional or school days to complete after the school's received that written consent. 50 school days is a long, long time. That doesn't count weekends, that doesn't count summer break, that doesn't count fall break, that doesn't count snow days, that doesn't count Christmas break. So there, it's straight out school days would be at least 2.5 months, at least. And when you throw in all the other things that come about during the school year, you're probably looking closer to 3 months or better. And so parents need to be really diligent about making sure they get that consent signed and looking to get that meeting scheduled. So the evaluation then, if the school again has agreed to further explore whether or not this child qualifies for services. So the school has to do that evaluation, because that evaluation provides that important information that will help determine whether or not a child in fact qualifies for special education services. And again, they can't start that evaluation without parent consent. So this is a really important evaluation. This evaluation provides that information that's needed to determine if the child qualifies. And not only that, if the child does qualify, it also provides some guidance as far as what services or supports that child might need. And so following the evaluation, the case conference committee is then going to sit down to meet to discuss eligibility and what services might be needed. And so that all has to happen. The evaluation process, sitting down with the case conference team to review the results, all of that has to fit within that 50 instructional day timeline. Parents do have the right to request a copy of the evaluation. I think it's up to 5 days prior to your meeting. Parents also have the right to request that staff, someone that's knowledgeable about the evaluation results, sit down and review it with them and answer questions prior to the meeting. So you can meet a few days before your case conference meeting and have it explained and have a chance to ask some questions. Parents are often feel a little overwhelmed in the bigger meeting, but if they can have somebody explain some things to them before the meeting, they're going to be in a better position. They've already heard some of the information, and better position to start asking questions at the actual eligibility meeting. Okay, so we've had the evaluation, we've reviewed the results. And so now we're sitting down at this case conference committee to determine, does this child in fact meet the eligibility criteria? So who is that eligible child? Student has to qualify for special education services and related services based on the criteria set forth in Article 7, Indiana's special education rules. And so it's not enough to have a disability. Doctors diagnose disabilities all the time, but the evaluation has to look at, does this disability, is it severe enough that it interferes with the student's academic achievement, the student's functional performance or behavioral? Functional can be behavioral performance, or both. Schools tend to just look at the academic piece. If a parent requests an evaluation and Johnny's making B's and C's, well, he's doing okay. He doesn't need to be evaluated. Academic isn't the only consideration. Functional performance is as well. So if you have a student who's getting sent to the principal's office on a regular basis because of behavioral challenges, or is getting a lot of in-school suspensions for behaviors or out-of-school suspensions for behavior, that's a red flag that maybe we've got some functional performance issues going on. And so the parent needs to, consider making that request for an evaluation based on some of those issues. But this evaluation process is designed to measure the amount of adverse effect. It could be possible that through the evaluation process, it's really determined that Johnny really is doing okay, even though he has ADHD, or possibly even a medical diagnosis of autism. If there are no behavior challenges, nothing that seems to be interfering with their functional performance or their academics, the school may say, no, we don't really see that he qualifies. Parent does have the right to disagree with that, but just kind of putting that out there so that you can be aware that sometimes it's not as straightforward as it might seem. So just to kind of summarize, the student has to qualify for special ed services, and based on that evaluation process, the evaluation process has to determine if there is adverse effect caused by the disability in academic achievement and functional performance, or possibly in both. In Indiana, there are 13 eligibility categories, and you've seen all of them. You have probably dealt with most, if not all of them. The one that I want to point out is developmental delay. A year or so ago, the state of Indiana finally adopted IDEA's age limit on developmental delay. In Indiana, prior to last year, it only applied to children 3 to 5 who were not yet eligible to go to kindergarten. So we had a lot of preschoolers that were being reevaluated before they went into kindergarten. They had qualified under a developmental delay, but you couldn't use it beyond then. And if we couldn't find another qualifying category of disability, this child would lose the IEP and lose services. Indiana has since expanded that age range from 3 through 8, in other words, up till the time they turn 9, 3 through 8, which is great because that means that even a 6-year-old can be evaluated for a suspected developmental delay. And we do know a lot of our kids do have those. They don't magically disappear necessarily, but often as kids get older, sometimes the child ends up being diagnosed with perhaps a learning disability or some other type of qualifying disability. But I love the idea that our kiddos can continue to receive supports for developmental delay up until they turn the age of 9, as long as they continue to qualify. Article 7 does have I call them the definitions, but the descriptions of each and every one of these, the educational description. And it is important to note that a medical diagnosis does not equal an educational eligibility. So I have seen kids with a medical diagnosis of autism. The school still has to do their own evaluation for autism. But if the school, through that evaluation process, does not see that autism is, creating a serious adverse or an adverse academic or functional performance issue, the school may not believe that the child qualifies under autism. Doesn't mean that they qualify under another category, but it's really important to understand a medical diagnosis does not automatically equal an educational eligibility for special education services. Some of those kiddos that really can't quite seem to qualify, there really needs to be a discussion about a Section 504 evaluation, and they can use that special ed evaluation as the basis for that evaluation, so that student might still be able to get some supports through a 504 plan. Okay, so let's talk a little bit about, let me go here. Okay, the IEP process. Once the child is determined to be eligible, we have to develop what's called an individualized education program, or an IEP. You all know, because I'm sure you have them as well. We use lots of acronyms, and so I have to be careful to explain what the acronym means, because not everybody has had that kind of background. So we're going to develop that IEP, and there's a team that develops the IEP. It is not just the school. Remember, I talked about the parents' role in the process. Parents should be very actively involved in this process. And so this case conference committee is made up of specific people. Parents, of course, should be at the table. Students, the child themselves, as appropriate. Younger children, maybe not so much, but certainly by the time we're talking about transition-related topics and a transition IEP, in junior high, we really need to get the kiddos involved in it, because we need to be helping them to develop self-advocacy skills. And so there should also be someone called a public agency representative. On the notice of a case conference meeting, all of the people that the school has invited should be identified on that notice, and it should also tell you their role, whether it's teacher of record or a general education teacher, public agency representative. This person is really important, because they are the ones with the authority to assign the resources, or in other words, to pay for whatever it is we've decided needs to go into this IEP. Most of the time that's not a problem, but if you have a parent who is wanting the team to consider a residential placement or a one-on-one aid, some of those decisions, especially for the aid, when we're talking about possibly having to hire staff, case conference committees don't hire staff. The school corporation does. And so parents need to be really proactive about getting that information to the teacher of record and making sure that the appropriate people are at that meeting that can actually make some of those decisions about, because somebody has to pay for it. So just kind of putting that out there, but otherwise you're going to find yourself having to meet again with those people. So someone else that should be there is the teacher of record. The teacher of record is really, really important. Parents really need to get to know that person. Teacher of record is someone who is appropriately licensed in the child's suspected or qualifying category of disability. In smaller districts, the teacher of record might also be the teacher of service. That means they may actually teach the student as well. In a lot of districts, the teacher of record just kind of oversees all of the students on their caseload, but other teachers actually do the day-to-day teaching. And so if it's a speech-language issue, then the speech-language pathologist is going to be the teacher of record, if that makes sense, because he or she will be the one that's appropriately licensed and trained in that area. And again, very important person. Teacher of record is the go-to person. I tell parents, get to know your teacher of record and make them your friend, because if you're having problems with the IEP or your student is struggling, this is the go-to person that can kind of get the ball rolling and trying to do some problem solving. Someone else that should be at the case conference meeting is an instructional strategist. That's somebody that does exactly what you see here. They know how to develop instructional strategies for children with disabilities. Often Many people wear more than one hat, so this might in fact be the teacher of record as well. There should be at least one general education teacher if the student has any courses in the general education setting. Most of our kids, I hope, certainly hope all of our kids have at least one general education class, and there should be one teacher that actually teaches him in that general ed class at that meeting as well. And then others with knowledge of the student's needs. Parents have the right to invite someone or others to attend with them. And I do encourage parents to let the school know if they're bringing someone, but they are not required by law to do so. But just kind of, in the interests of good communication, let them know if you've invited family or maybe someone from Insource or someone else that is going to support you, the parent, in the meeting. Okay, so let's talk a little bit about what the IEP has to contain. There's something called present levels of performance, and typically that's something that gets talked about early on in the IEP, and I can't stress how important present levels of performance are, because this should tell you accurately at that time of the meeting, how is this child performing academically and functionally? How are they doing? Not just grades, but a lot of schools are doing testing like star reading or star math. What are the most current scores? And how is this compared to his typical peers? Is he above where typical peers are? Is he right on target? Is he below? And if so, that's great information to know, because that means we may need to address that in some of our goals. So parents need to understand how is my child performing compared to other students in his grade. If he's below or significantly below, then you really need to be looking at addressing some of that further on in those goals. And so then, of course, you need to talk about how the disability affects progress. Disabilities do impede learning sometimes. Well, often they do. And so it can affect them academically and behaviorally. And so how does that disability, there should be a statement in that IEP about how the disability affects the student's progress in the general education curriculum. The IEP will also contain measurable goals, and those goals are going to, again, be based on present levels of performance. What are the skill deficits that he's got? How are we going to address those skill deficits? And so, when we see that there are problems, maybe we need to write a goal to address it. Sometimes you'll hear, several teachers mention, that, Johnny is so disorganized. He never comes to class with his supplies. He's not getting his homework turned in on time, but yet it's not addressed anywhere that you can see in the IEP. That's a red flag that, maybe we need to be writing a goal for developing organizational skills, because Johnny not getting his homework done or not getting his homework turned in on time is probably affecting his grades, right? Probably affecting his academics. Might in fact be getting him in trouble. He might be getting lots of detentions or whatever the consequence is for not getting things turned in. And if in fact this is a characteristic of that child's particular disability, we really need to treat it as such. Okay. There should also be a statement about how progress is going to be measured. Please remind your parents that progress toward goals are required. Typically, they are sent out about the same time that report cards are sent out. I don't get the impression that parents really understand what this document is. And this really is important, because this is telling you, is Johnny actually making progress toward these goals that we wrote the last time we had a case conference meeting? The goals are written for a year out. And so we should be able to chart progress toward achieving whatever we decided was the goal that needed to be met within a year's time. You don't want to wait a year and find out he didn't achieve any of these things. So that's why you're getting this information periodically, so that parents can be on top of, is he in fact making progress? And if he's not, the parent needs to consider reconvening a conference to revisit those goals and why he may not be making good progress toward achieving them. Again, don't want to wait a whole year to find out that he didn't come anywhere near to achieving those goals. You want to address it as quickly as possible. And then there should also be information about what special education and related services the student might be receiving. So how much time is there being spent in the special education room or resource room, they might call it. Is he receiving occupational therapy, speech therapy? How often and how much? All of that should be very clearly detailed in the IEP. There's also a place for extended school year, or ESY. It's kind of limited. Most kids don't need this, but it is a discussion that if you're going to have it, you want to have it early in the spring so that you all have time to think about it and, consider, does he, come May, have we spent all year getting these behaviors on track? And if he's out of school for 2.5 months, is he going to lose all that progress that we made? And we're going to have to start from scratch all over again in August. And, if that's the case, then we may want to look at doing some extended school year, which is not summer school, by the way. And, maybe meeting a few times, several times over the summer in a school setting to reinforce whatever that learning was that we don't want to lose and have to start all over again in August when school starts again. But so start considering that and discussing that early in the spring. We have to talk about what the student's least restrictive environment is, and I'll talk about that in a little bit more detail in just a moment. Also a statement that there's a transfer of rights to students at the age of 18. Students become their own parent for educational purposes, unless a parent takes guardianship. And then also in the IEP should be something called written notes of the meeting. This is something that's really, really important, and I don't think parents understand how important this can be. Basically, the scribe at your meeting is summarizing the discussion that is happening at the case conference meeting. And I've read some written notes that were very, very brief and did not provide much detail of information. And when you talk to a parent and they said, well, we talked about this, this, and this, and you read through the IEP and there's no mention of it anywhere, then, what are you going to do? And I like to tell parents, if it's not written in the IEP, it didn't happen. Agreements for services should be written in the appropriate places within the IEP, but written notes, that summary of the discussion, are important as well, because parents can share concerns, schools can share what they've been doing, and it's just really, really good to pay attention to what's in there. I encourage parents to ask to have, after a discussion about a particular issue, to ask to have what we talked about read back to the team right there and then, because if there are some corrections that need to be made, you can do it right then and there rather than trying to fix it, a week or two later. Everybody from the meeting is still there and everybody heard the same thing, and hopefully we can make some corrections there. Okay, so placement, placement should be in what we call least restrictive environment, or again, our acronyms, LRE. And basically, according to the law says to the maximum extent appropriate, and understand every student is different. The student must be educated in the general education setting that their typical peers would be educated in. And that's actually been in the law for a long, long time. We don't always see it happening that way, but we are seeing that I think we're getting better at it. All kids with disabilities, even the most severe, need to spend some time with their typical peers. And what studies have shown is that kids with disabilities tend to have better adult outcomes after school when they've been educated with their typical peers. how do you do that? Well, remember we talked about specially designed instruction under that definition of special education. And so if Johnny, who has a learning disability, is sitting in a math class, and math is a very difficult subject for him, we need to be looking, to develop that IEP to provide supports and services to him in that special ed or in that gen ed classroom to help him to learn what the other kids are learning, but he may learn it differently, that specially designed instruction. Some kids may not need to have that, changed out, or may not need support in a particular class, but if they have an IEP, they probably will need some specially designed instruction. So if we write a good IEP and put some appropriate supports and services in place for them, they can hopefully do most, if not all, of their classes in a gen ed setting. And again, this is highly individualized. The more severe the disability, the more likely there's going to be a more restrictive placement for them. And so it goes on to say that special classes or separate schooling or someplace other than a gen ed setting should occur only if education with their same age peers really can't be achieved well based on the nature and severity of the student's disability. And the case conference committee is the one that decides what least restrictive environment will look like for each child. So when we talk about LRE, or least restrictive environment, we've got a continuum of placements, and this is really important. And I don't think parents often understand that there is a continuum. The least restrictive, of course, is the general education classroom where their typical peers without disabilities are being educated. We want our kids with disabilities in that setting as much as possible with appropriate supports and services. A somewhat more restrictive placement could be a resource room. Some of our kids will take their direct instruction in the gen ed classroom, and then they'll go to what we call a resource room with a special ed teacher and aides to receive some individual one-on-one assistance or some reteaching to help support them. That's something that could be done. Some kids might do their entire math class in a resource room, or an entire English class in a resource room. Again, the case conference committee decides the appropriate placement. A more restrictive placement is a separate classroom. And so that's basically what I think we sometimes call self-contained. These are often kids with emotional disabilities. Sometimes we put our kids with autism in there if they have behaviors that really cannot be managed well in a general education setting or a less restrictive setting. Some kids require a higher level of supervision and support. And again, that's a case conference committee decision. And even then, these kids hopefully will be getting some classes in gen ed, whether it's music or art or perhaps a gym class. They still need time with their typical peers. A more restrictive placement is a separate non-residential school. And basically, the case conference committee, the parents and the school have to agree that this is appropriate, because the school has to pay for it if the school believes that this is appropriate. Sometimes the nature and severity of a child's disability is such that the school really does not have the resources or the setting to address those needs appropriately. And again, I want to stress, it's a case conference committee decision, because there is a fee attached. We sometimes call these day schools, and there are some throughout the state, and but it is something on that continuum. There's also a more restrictive is a residential school, and again, parents and schools have to agree that this is an appropriate placement before the school will pay for it. So a parent may request it, but it is a case conference committee decision, and you all need to be talking about, if, why the school hasn't been able to meet this child's needs. And the school has to agree that they can't meet their needs before they'll agree to pay for it. And of course, parents and schools do disagree sometimes, and there are options for working through those disagreements. The most restrictive is homebound or a hospital setting, and that's not all. Hospital settings don't happen very often, but they can. Homebound is the one that I want to focus on. You'll notice we've looked at that continuum, and a lot of our kids that are in a separate classroom, often because of behaviors, when things really go south, sometimes the default placement with schools is homebound. Well, we'll just put them on homebound, and we'll provide 3 to 5 hours of instruction with a teacher at a library every week. That may or may not be appropriate. It's not my call to make, but just be aware there are some drawbacks to that. Number one, they are not spending any time at all with typical peers. Number two, whatever those behaviors are that are affecting their ability to learn effectively at school, how can the school teach better or more appropriate behaviors if the student isn't at school? I mean, something to think about. And number three, 3 to 5 hours or whatever the school is offering is a lot fewer hours than the typical student would receive at school. And again, I'm not saying this is that parents shouldn't ever do this. They just need to be aware there can be some pitfalls. I've had some situations where we did a combination of homebound, but then also had the child come back to school for a couple of core classes. You run the risk of not getting the education that you need. And this really gets critical when kids are in high school and we're supposed to be working on core classes to earn credit. So again, every case is different, and you've got to have a really, really robust conversation at your case conference meeting, in making some of these decisions. I want to be very clear. The Indiana Department of Education has made it clear that they believe that kids with disabilities should be educated at school. And so whatever the plan is, if they're being taken out of school, we really need to give good consideration to working as quickly as possible to get that child back into school and making sure that they've got the supports and services that they need. I've seen cases where kids have been on a partial day for years, and that is probably not appropriate. Okay, so we talk about instruction. The case conference committee has to consider how instruction will be delivered to the student. And again, that gets written into the IEP, who's teacher, how much time in the special ed classroom or wherever the classroom might be, what those supports and services will be in the gen ed classroom if he's going to be in there, what sort of related services are going to be provided. All of that has to be clearly documented in the IEP. The annual case review, it's important to note that once we have an IEP in place, the Article 7 requires that the team meet at least once a year for an annual case review, or the acronym ACR. So teams must meet at least once per year. What parents often fail to understand is that they can convene a meeting more often if they need to. If Johnny's starting to struggle academically in a class or two, or struggle behaviorally, the parent absolutely has the right to request that they convene a meeting to sit down and review what's going on, to make any necessary revisions, maybe to do a functional behavioral assessment if there are behavior plans, or if there are behavior problems. So it's just really, really critical that parents know they can convene when needed. And schools can as well. But we must meet at least once a year, but may certainly do more often as needed. Reevaluation has to be considered but is not required to be done every 3 years. So after 3 years of having an IEP, you all will be having a discussion. Actually, you probably may mention it every year, but the reality of it is, if parents and schools feel that there's sufficient information, sufficient data to proceed to write an IEP, a reevaluation is not required. However, parents or schools at any point in the process can pipe up and say, he's really getting worse in math. Something's going on. Things change with our kiddos. They do. And sometimes we're not quite sure what's going on. We just know that something is missing, something is slipping badly. And sometimes we need some really updated assessments to get a better sense of where is this child academically? Has he developed some deficits that he didn't have before, or have some of the deficits worsened? And that's good information that you need to help to revise that IEP and to maybe boost some of those supports and services if needed. So just remember, parents and schools can say, hey, I think maybe we need to do a reevaluation because. And so then you can now see with all of these arrows going around, just kind of start that process over again. It is a process, and there are steps in the process. I want to spend a couple minutes talking about finalizing the IEP. This is really important. For that very first IEP, no services can be provided until a parent signs consent for special ed services. So if you're at your eligibility conference and we've all agreed that yes, Johnny does qualify under a specific learning disability, the parent, if the school cannot provide any of those services that we've all talked about until the parent signs consent. So sometimes parents have disagreements about certain facets of the IEP, and they have the right to do so. And if that's the case, they really need to, work hard to meet with somebody that can help to resolve those disagreements, because nothing's going to happen until you sign that IEP. Okay. And we'll talk about some options to get around that in a minute. But if you do agree with the IEP substantially, you can go ahead and sign it, and services will then start. For revised IEPs, these are IEPs that are no longer the very first IEP. School does not require, the law does not require your consent to implement a proposed IEP unless you challenge it. So what happens is you go to a meeting, sometimes the school will ask you to sign to implement the IEP that you guys have been revising. Some parents will do so, and that's fine if you're in agreement, but the school does have the obligation to get you a copy of that proposed IEP. In other words, capturing all of that discussion, all of those decisions that were made during your meeting. They need to get you a copy of that in writing, and they can send that electronically, which is kind of cool. Parents really need to review it to make sure that it matches what they remember from their discussion, because they may find that, oh, I thought we said he'd get 30 minutes of speech a week, and this only says 20. In which case you want to call the teacher of record and say, I thought we said, and have that discussion and hopefully get it squared away, get it changed, and then get that hard copy out. But once you get that copy, you have 10 instructional days again to review it. And if you agree with it, then get it signed and get it turned in. But if you don't agree, you can challenge the IEP, and it's important to note the proposed IEP. It's important to know that the current IEP will remain in effect until you guys work through your disagreements on the revised IEP that you just had your last meeting about. So parents and schools need to work through the difference. Let me go in here. Let me go back here. You can challenge the IEP by asking to meet with school staff that's in a position to work out some of those disagreements. Reconvene that case conference, get it all out there again. Hopefully you can work through those disagreements and come to an agreement, get it signed, get it implemented. Written opinion, sometimes parents substantially agree with what's been proposed, but maybe there's a couple of small sticking points, but they don't want to delay the implementation of this IEP while they work through those disagreements. They can write what's called a written opinion. Actually, any member of the case conference committee can write a written opinion, but it has to be submitted within 10 business days after your meeting. And it's just kind of a way to document any issues or concerns that a parent or others may have had about the discussion, about the IEP, and you can make suggestions for improvement or what you would like to see happen. It does not become a part of the IEP, but it goes into the schools or into your child's school record, so it's still there. And sometimes the special ed director generally will read this, and they may decide to weigh in. And you never know. I've seen it happen where the special ed director made some proposals for, making some changes, and you guys can write that into the IEP, and parent agrees to it. Then maybe you've got some of those things squared away that you as a parent were hoping to have happen. So written opinion can be a way to document some disagreements or concerns without delaying the implementation of the IEP. So again, remember, for the very first IEP, there is no IEP until the parent signs consent for the school to provide special ed services. For subsequent IEPs, IEP revisions, the parent doesn't have to sign consent, but if they challenge the IEP, they need to do so within 10 instructional days of having received a copy of the proposed IEP. If a parent does nothing, doesn't challenge it, that proposed IEP goes into effect on day 11 after the parent received the written notice. So we talked about that, or received the hard copy of the proposed IEP. Parents and schools do disagree. That's why I'm in business, I guess. Well, that's not the only reason, but we strongly believe that good communication between parents and schools is really a great way to avoid disagreements, or at least to have a better platform to work through those disagreements. We do know from studies and probably from personal experience that students tend to have a better outcome when parents and schools work together as a team. And that doesn't mean parents always have to agree with schools or vice versa, but understanding that this is a team effort. And so, but sometimes there are things that we just kind of can't work past, and the law does provide some ways to work through those. A complaint is something that a parent may file against a school district if they believe that the school is not following Article 7, Indiana Special Education Rules. Perhaps they didn't follow some of those timelines, such as for evaluations. Maybe they didn't provide parent written notice, refusing or agreeing to evaluate. Maybe the school isn't following the IEP as written, which is required. If something's written in the IEP, it has to be followed as written. Parents can file a complaint with the Department of Education to try to work through that. What I tell parents, though, is remember your teacher of record. Again, everything in writing. This is a great way to start the process, and it's something that I've used in the past. Contacting the teacher of record to say, hey, I don't think he's getting his tests read to him out loud. He's telling me that he's not, and I can see that his test grades are falling. The teacher of record is that their role is to work with other school staff to remind them, this is what's in the IEP. This is what needs to happen. And if that doesn't get fixed, then a parent may choose to go ahead and file a complaint. And you can file without calling the teacher of record, but in the interest of good communication, you may want to try to do the quick and easy, hopefully quick and easy fix. So again, technical violations of Article 7 can be a complainable issue. But what happens when there are matters of opinion? I think my child should have 60 minutes of speech every week, and the school's only proposing 30. Okay, that's kind of a matter of opinion, because there's nothing in Article 7 that says every every student that needs speech services is entitled to 60 minutes of speech. It does not say that. That's why that's the I in the individualized. Every student is different. So parents have to learn to become effective negotiators. Schools make their determinations and their proposals and their decisions based on data. Parents need to do the same thing. If you believe your child needs more speech services, if your child's getting outside services, you need to collect information to share. You know, if you've got an outside provider, get some reports from there to share with the school to say, you know, this is why I'm asking for this. So the important thing is, if you disagree with what the school is proposing, really the first step that you need to take is to ask to meet with someone in a position of authority to resolve disagreements. Typically, this is done through a reconvened case conference. But be sure that you do that within your assigned timeline. Please do it in writing. You can email the teacher of record, the building principal, whoever you want that was on that team, to make sure that they know that you're in disagreement with, and then outline those pieces that you disagree with and ask to meet again. Another option, maybe you've met about this, this situation and you haven't been able to resolve it. There is something called a facilitated IEP meeting, or an FIEP meeting. It's really kind of cool. Parents and schools both have to agree to it, but basically there's a form that gets filled out. The Indiana IEP Resource Center sends facilitators, but you make the request, it gets faxed to Indiana IEP Resource Center. They will then set up another meeting, another case conference, and they will come out and they will facilitate these meetings. And these are for, you know, if you've got challenging or very complex cases, these can be very effective, because these folks from Indiana IEP Resource Center, these guys are pros. These guys and gals are pros at this. They will have an agenda. There will be no jumping around all over the place the way sometimes our meetings go. And you will stay focused on the issues for discussion. And it can often bring about some agreements that then gets written into the IEP, and we all sign off on it, and we're good. Another step that parents can take is they can request that the school mediate an issue. Again, you know, if it's a big enough issue that you're really concerned that this is going to have an adverse effect on your child, it may be worth taking that step. Understand the school does not have to agree to mediation. Typically they do, but there's also a form that you and the school, parent and school, will fill out identifying what those issues are. And a mediator will be assigned by the Indiana Department of Education at no cost to the parent or to the school. And then you will have that mediation session. Again, hopefully you'll come up with an agreement that everyone can live with, or substantially live with, and it can be implemented. There's also, parents can also file for a due process hearing. The school does not have to agree to this. This is something that a parent can simply file for. It's a much more a much more complicated process. It's much more formal. It will go to a hearing officer. It'll be heard by a hearing officer. The school will be represented by their attorney. Parents can hire an attorney if they choose to, or they can represent themselves. And both sides can present evidence, can call witnesses, and then the hearing officer makes the decision. The school doesn't make the decision, the parent doesn't. The hearing officer does, based on the evidence that's been provided. And so it's a very formal process. It can be expensive if you have to hire an attorney, if a parent has to hire an attorney, though if a parent prevails, they may be able to go to court to have the school pay some or all of their attorney's fees. But you don't know that that's going to happen until it happens. So, you know, it's certainly absolutely an option for parents, but it's one that you do not want to, a step you want to take to without knowing what you're getting into ahead of time. Parents also have responsibilities to participate in the process, provide written consent at various times in the process, and certainly to attend case conferences. If you don't attend these case conferences, decisions are going to be made without your input, and also to serve as your student's advocate. One thing I neglected to mention, parents always need to provide their parent concerns, hopefully before the meeting, so that the school can get that written into the IEP so they can be addressed. Hopefully parents are creating a home file. This is something that you might be able to help your families with. Start putting all of this paperwork in one place where it can be easily accessed, everything in chronological order. Parents may or may not have some of these papers because things come and sometimes we don't realize how important they might be. They can ask the school to make copies of the pieces that are missing, but the school does have the right to charge a reasonable copying fee. So just in summary, there's a process that we have to follow for special ed. Parents really need to understand that they are equal members of this process. Parents need to keep good records. And the reason for keeping good records is because to review them and so that they can know their concerns and bring those concerns to the table, because you can't fully participate in a process if you don't have all the information in front of you. And parents just really need to be proactive in making sure that they're on top of how their child is performing at school and has performed in the past. Try to work through those disagreements at the lowest level if possible, starting with that person with the authority to resolve disagreements, and generally that can be done in reconvening a case conference meeting. Try to work it out there if at all possible. And then if you can't make it work that way, you can always proceed to other more formal dispute resolution options. We do have a volunteer program. I'm not going to go through that right now. Here's our contact information. I want to go briefly through the handouts that I had shared, and hopefully you've got them. I shared something that we call, I affectionately call it our parent packet. And it's basically information that I share to parents when they have a case conference meeting coming up. And so it's kind of information on preparing for a case conference meeting. This has got some really, I think, pretty fabulous resources, and I truly hope that you'll print off at least some of these to share with your parents. It kind of starts with a letter outlining what's to come in terms of the handouts. The first one that you'll come to is a reminder for parents attending case conferences. It's 2 pages, and this is what I give to all of my parents because I don't go to everybody's meetings. I can't, but it's kind of a combination of tips and hints for preparing for the meeting, for when you're in the meeting, and maybe even after the meeting. And but it also contains some parent rights information. And most parents are not aware that they do have the right to say, I think we need to stop the meeting and reconvene because I don't think we're getting anywhere at this point. Or the school, you've been in the meeting for an hour and the school's saying we have to end. I've got more parents coming in, but you as a parent feel like, whoa, wait a minute, I don't think the discussion is over. A lot of parents will just say, oh, okay. And they end up with an IEP that they really feel didn't fully address all of their concerns. Parents have the right to say, let's schedule to reconvene because I don't feel like we're done with our discussion. So just things like that. Really, really important pieces. And I call it kind of a cheat sheet, pocket advocate, if you will. Take it with you to meetings. You guys can keep it when you're talking to parents. You can kind of reference it and say, oh, by the way, you have the right to be fully informed, or you have the right to not have to sign that IEP right at the case conference meeting. The school has to get you a paper or a hard copy of that proposed IEP for you to review. Another link in there's a link to our website for a video called Preparing for Your Students Special Education Case Conference. I always direct my parents there. It's only about 35 minutes long. If they can't come to an in-person training that I'm doing, or they can't attend a webinar that I might be doing on that topic, they can sit in the privacy of their own home and watch this 35-minute video, and it will tell them things that they need to know and things that they need to do to hopefully, get a better outcome at their meeting. We have to encourage our parents to become more proactive in becoming advocates for their kids. They need to learn this stuff, and these are some, well, easy, some are easier than others, but things that parents can do to better represent their own child. So please feel free to share that with your parents as well. I also included what we call an Article 7 timeline. This is basically, it starts at the beginning from the time that a parent makes a request for an evaluation. It talks about what should happen. It talks about those timelines, but it also takes you, into the future. So a year from now, we should be having a meeting. You can revise, every 3 years, we should at least be considering a reevaluation. And that too is a cheat sheet of sorts that you as staff might want to have handy, so you can reference it when you're talking to a parent, just kind of a reminder, and certainly you can share that with them as well. I provided a document called Getting the Most Out of Insource, and basically it says this is what we do, kind of like what we did right at the very beginning of this presentation, but it's kind of a handy-dandy little piece of paper to say, these are things that we can do for you, or services that we offer, and what have you. So you can use that to share with parents if you would like to as well. So please review that packet that I shared. Really good information for you, but information that you can easily share with your parents as well. And face it, that's kind of what this is all about, is getting that information out to parents and to support them as much as possible. Okay, I think I'm at the end, so I am more than willing to take questions at this time.
Thank you, Kathy. That was fantastic information and wonderful insight. Currently, I'm not seeing any questions in the question area, but perhaps people are just starting to type those up, so I'll give it a minute here. And while they're doing that, I just want to remind the staff that are on the call, the attendees on the call, that I have the information. It does sound like somebody just commented that they do have the handouts, and they can be sent again. Thank you, John, for that. But I also have them. Michelle has them. So if anybody else needs those, please just let us know, and we'll be sure to get those to you.
Great. That it really is good information. And I guess one thing I do want to kind of emphasize is within the IEP itself, there is a section for parent concerns. And I talk to parents sometimes for half an hour, 45 minutes, an hour, and I hear all sorts of concerns. But when I read the IEP, all it says is under parent concerns, parent has no concerns at this time, or something a very brief summary that really isn't very clear. So I tell parents that worksheet of that worksheet of concerns is actually in that document as well. Encourage them to articulate what those issues are or concerns are that they want to address at the meeting. They can share that information with the teacher of record and ask that those be copied and pasted directly into parent concerns in the IEP, because it does a couple of things. It memorializes in writing in the IEP that the parent had these concerns. The other part of it is it ensures that the case conference committee team is going to have to discuss those issues and come to some sort of plan for them. It might just be, we're still in disagreement and we're going to have to meet again, but you have to address them. And so I really don't like it when I see parent concerns that says parent has no concerns at this time, when I know they did. But so parents need to be encouraged to articulate or to share those concerns directly with the teacher of record and ask that they be added directly to parent concerns in the IEP to ensure that there's hopefully a good discussion at your meeting and a resolution. Okay.
Okay, well, I'm double checking, but it doesn't look like, lots of thank yous. And Sam, I will let John go ahead and send you those, but if you I'm sure he'll send those soon. But if Sam, you need anything else, just let me know. And then Kathy, it looks like that would be it for today. So thank you again ever so much for all of the information and the insight. And yeah, obviously your experiences, sharing those are super valuable with us. So we appreciate that greatly. And I just want to thank
Okay.
everybody that got on the call. So
Now, Marcy, does everybody, all of your staff do they get a certificate of sorts from you
yes,
for having attended? Okay.
yep, they will just need to fill out a form to submit to our quality and training manager. And then with the completion of that form, they will get credit for attending the training today.
Okay. And hopefully everybody was able to follow that registration link that we generated. Unfortunately, part of our grant requires that we collect demographics, so we need
Okay.
names and
Well,
numbers, and
what
I
we
know.
do from the recording too is I can work with Amy to print out a list of attendees. We can see how attentive they were and all sorts of fun things from the reports that we can pull from these webinars. So yeah, if for some reason you think that's off, just let us know. Excuse me, and we can definitely make sure that you get that information. We can generate those reports on our end and get that to you as well.
Great. Great. Well, thank you so much for being so attentive, folks. And you can always contact me at cboswell@insource.org if you have specific questions. And I know you're all busy and you all have lots of things to do. So thank you so much for joining us today. I appreciate the opportunity.
Thank you, Kathy. We appreciate it as well. Have a great rest of your week, everyone.
Thank you.
Bye-bye.
Bye-bye.